morning and thank you for joining us again. Today we have talks from Avtar Kanguri QC on economic duress and from Natalie Kearney on personal guarantees. Then tomorrow we have a personal insolvency case law update from Raghav Trivedi and Amanpreet Kaur, and then James Morgan QC will speak about the current state of the law and misfeasance. At the end of this week we'll be sending out feedback forms. We'd be very grateful if you could fill those in. In particular, this is the second year that we've run the conference online, and we would like to know your views on whether this suits you better or whether you would prefer to revert to a day in person. For my part, I'm keen to get back to seeing you face to face again, but it's not my view that matters. Please do let us know what you prefer. Back to today's talk. Please do send any questions you have in the Q&A or the chat function, and we'll try to deal with as many as possible at the end. Avtar.
Good morning. For those of you who don't know me, my name is Avtar Kanguri. I've sort of had a realisation this morning that I am now perhaps one of the most senior members of the Insolvency group here in Chambers. I started work or practising in insolvency as far back as the 1980s, having completed my pupillage at what is now 3 to 4 South Square. The subject matter of my talk this morning is economic duress. When can acting lawfully be deemed to be illegal? The reason I chose this topic for this seminar, because it does have some connection to insolvency, as well as being a subject matter that I've been interested in for some time. It first came up really in the late 1990s during my practice and the early 2000s, because we went through a spate of insolvencies in relation to suppliers to the automotive industry. And some of you may recall that it was common practice, and perhaps still is as far as the major manufacturers are concerned, that they worked to what was called just in time, whereby they would keep parts in store on site for their production lines, which would last no more than 2 to 3 days. The main motor manufacturers would also enter into contracts with their local suppliers, whereby the terms of the contracts were quite onerous, which would give them the ability, for example, to renegotiate certain terms after the contracts had been entered into, and more importantly, to impose retrospective rebates. The result of that was that on certain occasions, the supplier would get squeezed so much by the larger motor manufacturer that it would lead to their insolvency. On one occasion, an example that I can remember, a very large motor company based in Detroit forced one of its suppliers, who provided some parts towards the gearbox of a popular car, to keep cutting its prices, and also at the end of the year, when it realised that it wasn't making sufficient profits, to retrospectively recover some of the money that it had paid this supplier, which in turn caused that supplier to go into administration. I acted for the administrator in obtaining the administration order. In those days, court applications had to be made for every administration. And then we found that in turn, the motor manufacturer couldn't continue its supply chain whilst this company could not produce the relevant part, and therefore, ironically, was forced to fund us starting production again and underwrite any losses, which meant that they had to increase the prices on the contract. So at that stage, some consideration was given as to whether we could bring a claim by the administrators against the contracting party, the motor manufacturer, for economic duress, and it was felt that the subject matter was too difficult to prove, but that is one reason why I have kept an interest in the subject matter. Now, having done some research into it, and the reason I'm doing this talk today is that last year, in a case called Pakistan International Airline Corporation against Times Travel, the Supreme Court considered this subject matter once again, and it's that judgment that I want to go to. And there has been some debate between the academics who think that as an academic subject, the concept of economic duress based upon lawful actions is something that exists and ought to be put into play by the courts, whereas the courts have always accepted that such a concept exists, but have been reluctant to actually lay down any boundaries or principles as to when it may be applied. Now, what I'd like to do first is to simply go over some principles of an overview, so to speak, of what economic duress is. Now, English law places a great deal of importance on the enforceability of contracts, and most of us know what those principles are, but there are vitiating factors also when a contract, although that it has been entered into by the parties, can be set aside or declared to be void ab initio by the courts. For example, fraud, misrepresentation, undue influence and duress. So in equity, in common law we have fraud, misrepresentation. In equity we have undue influence, and duress, sometimes it's unclear as to where that sits. In a case called Bustani and Pigott, which was heard by the Privy Council in 1993, what the Privy Council said when they're considering an equitable intervention is that it's hard, that they said that they will not intervene because the bargain is simply hard, unreasonable or foolish, or where there was unequal bargaining power or the terms of the contract were objectively unreasonable. Now, in another case called Universe Tank Ships Incorporated of Monrovia v International Transport Workers Federation, which is a 1983 case, the court was considering the actions of members of the trade union who demanded payment from the ship owners, threatening that they would otherwise see to it that the tug services were withheld, leaving the vessel stranded in the port. Now, the House of Lords held that the agreement to pay for the release of the vessel made following such unprotected threats had been procured by economic duress. Again, the reason behind that was they considered that the actions of the trade union members was unlawful. Now, there's no problem where the actions of one party are unlawful to set aside a contract on the basis of economic duress. But what their lordships also said was as follows. They explained that the rationale underlying economic duress is as follows. Where a party's consent to enter into a contract was the result of illegitimate pressure being brought to bear upon by the counterparty, the law ought to provide redress. The House of Lords proceeded on the basis that the economic or commercial pressure could, in principle, be illegitimate if it left a party without any practical choice or alternative. So far, so good, and I agree entirely with it. But Lord Diplock also took the view that commercial pressure, which amounted to a coercion of will of the other party, had to be justified in order to be legitimate. And what he seemed to be doing there is to shift the burden of proof. So some confusion came into play there at that stage. Lord Scarman recognised that threats may relate to actions which are perfectly lawful. So again, it left the door open a little bit, that if lawful action is taken, in some circumstances, without setting out what those circumstances exactly were, it could be sufficient to amount to economic duress, which allows the court to set aside the contract. Now, in 1994, in another case called CTA and Cash and Carry in Gallagher, the Court of Appeal were asked to consider the question again. What happened there was that Gallagher, a major manufacturer of cigarettes, provided credit facilities for purchases to its customers, mainly wholesalers. A consignment of cigarettes was stolen before it reached the claimant's store. Gallagher considered that the risk had already passed to the claimant when the goods were stolen and pressed for payment. The claimants declined to pay. Gallagher withdrew its credit facility and demanded payment before reinstating it. This was not a breach of contract, as there was no ongoing obligation on Gallagher to provide credit for the future. The claimants reluctantly paid the invoices for the stolen goods, but then commenced proceedings to recover the same. The Court of Appeal rejected the claim against Gallagher because they said that although Gallagher had applied commercial pressure to recover a payment which it had believed in good faith to be due, there was no breach of contract. The court declined to extend the doctrine of economic duress to pressure applied through lawful acts where the party making the demand honestly believed that it had an entitlement. Now, Lord Steyn in that case, as he then was, said, "We are being asked to extend the categories of duress which the law will take cognizance. That is not necessarily objectionable, but it seems to me that an extension capable of covering the present case involving lawful act duress in a commercial context in pursuit of a bona fide claim would be a radical one with far-reaching implications. It would introduce a substantial and undesirable element of uncertainty in the commercial bargaining process. Moreover, he said, it will often enable bona fide settled accounts to be reopened when parties to commercial dealings fall out. And he finally added, and this is the important part, in this complex and changing branch of the law, I deliberately refrain from saying never, thus leaving the door open for lawful actions being considered to be sufficient to set aside a contract on the grounds of economic duress. Now, in that context, we need to look at what has happened recently in the case of Pakistan International Airlines. And before that, I think we need to go to the next slide, which is Morley. There you go. I want to refer to one other recent case. Now, some of you may be familiar with Morley, trading as Morley Estates against Royal Bank of Scotland plc, because that was really a case where Morley was attempting to set aside certain transactions, i.e. the swaps cases that had been fairly common throughout the late part of in the last 5 or 6 years. And what he sought was rescission of the financial structuring transaction entered into with the RBS on a number of legal bases, which included the allegation that he had been induced to enter into such agreements by intimidation and economic duress. Now, you may find when I tell you the facts of Morley quite briefly that there is some truth in what Mr. Morley was alleging. What RBS did in that case was present Mr. Morley with two options. He either, one, signed up to the restructuring documents as presented by RBS, which involved, amongst other things, a debt write-off, a substantial payment that was to be made by Mr. Morley to RBS in return for retaining title to various properties in his portfolio, and a consensual transfer of the remainder of the properties owned by Mr. Morley to RBS's subsidiary called West Register. Again, West Register may be familiar to a lot of you. It was a company that was set up by RBS that when they repossessed, through their structuring arm, when they repossessed properties or put them into receivership, they put them into their own company, property owning company. The alternative was that RBS would appoint an LPA receiver to the entire portfolio of properties and implement a pre-pack transaction under which all of the properties would be transferred to West Register in return for the discharge and release of the secured debt obligations. Mr. Morley alleged that the pre-pack option would be illegal, but the court did not agree. Now, the difficulty for Mr. Morley's case was therefore the fact that he was not threatened with anything which, if carried out, would have been demonstrably illegal. Now, of course, it sounds to me to be pretty immoral what the bank were doing, but it wasn't illegal. Mr. Morley's debt facilities were in default and he could not repay the accelerated payments due, and so the RBS was perfectly entitled to appoint an LPA receiver and implement on the facts a pre-pack transaction, as threatened. Now, he lost at first instance, and so Mr. Morley appealed, and he lost in the Court of Appeal. But the judgment of Lord Justice Kerr, the Court of Appeal, said this: the straightforward answer to the appeal on the issue of intimidation and economic duress is that, on the facts, the judge was plainly right to decide that Mr. Morley was not coerced by the bank's threat into concluding the agreement in question. So the main problem that Mr. Morley had in trying to establish economic duress was that the thing threatened by RBS was lawful and had long been an established principle of law in this area that duress is difficult to establish unless the cause of action threatened is an illegal act. And that was the end of Mr. Morley's case. We then come to the next slide, if I may, which is Pakistan International Airline Corporation against Times Travel. Now, this is the Supreme Court last year considering the issue of economic duress once again. Now, the facts of this case are quite relatively straightforward. Times Travel UK Limited was a travel agent business based in Birmingham. which had entered into a sales and commission contract with Pakistan International Airlines Corporation, which was the national flag carrier airline of Pakistan. At the relevant time, PIAC was the only airline which flew direct passenger flights from the UK to Pakistan, and it was therefore in a monopolistic position as regards the UK to Pakistan passenger air travel market. Times Travel's business at the time consisted solely of selling flights to Pakistan on PIAC's aircrafts, in return for which it was entitled to a commission payment from PIAC. A dispute arose between PIAC and various UK-based travel agents as to whether certain commission payments were due and payable by PIAC. Now, what the airline contended was that the payments were not due, and the travel agents argued that they were due. The finding in the first instance proceedings was that the airline had genuinely believed that it had a valid defence to the claims for past commission, and was therefore not acting in bad faith in this regard. Now, the airline applied pressure to Times Travel not to join in the dispute proceedings in respect of the payment of past commissions, and it gave notice to Times Travel that the current contract between them was to be terminated. It also cut Times Travel's allocation of tickets from 300 to 60, thereby drastically reducing the commission payments that they could earn for the sales. Now, it was not disputed between the parties that the airline was within its legal rights in both respects. In other words, it was entitled to terminate the existing contract, and it was entitled to cut the allocation of tickets. At that time, the airline then presented Times Travel with a new contract which contained an onerous waiver term in respect of Times Travel's claims for the payment of past commissions, and informed TT that if it did not sign the contract in this form, then the relationship between the airline and Times Travel would come to an end. Now, what was clear and was also accepted by all parties, that the termination of the relationship would have put Times Travel out of business, and therefore Times Travel reluctantly signed the new contract, including the onerous waiver provisions. 2 years later, Times Travel commenced a claim against the airline, alleging inter alia that it was entitled to rescission of the new agreement because it had entered into it under economic duress, and consequent to the rescission of the new agreement, that it was entitled to payment of the past commissions which had been in dispute previously. The case first came before Mr. Justice Warren, who held that Times Travel was entitled to rescind the contract for economic duress, even though he acknowledged that the airline had acted perfectly lawfully and had acted in accordance with its contractual rights. When the case came before the Court of Appeal, it held that as the relevant threats and actions in respect to the contract termination and the reduction in ticket allocation were lawful, duress could only be established if the airline had been acting in bad faith on the basis that it had not genuinely believed that it had a defence to Times Travel's claim for past commission. Since at first instance, Mr. Justice Warren had established on the facts that the airline did have a genuine belief it had a defence to the claims, the Court of Appeal said lawful act duress had not been made out. It was not sufficient that the airline's belief that it had a defence was unreasonable, since in the context of lawful act duress, there is a critical distinction between bad faith demands and unreasonable demands. If I just pause there, so what the Court of Appeal appears to have done here is to brought in to this concept of lawful act undue influence an element of bad faith, which was mentioned from time to time in passing by previous decisions, but was not considered to be an element that had to be established, or in the way that it had been applied by the Court of Appeal. Therefore, permission was given by to Times Travel to take the matter up to the Supreme Court. Now, when it came before the Supreme Court, we find that the court was divided. It was unanimous in rejecting the appeal on the basis that economic duress was not made out where the airline had acted lawfully, but they were split on the issue of bad faith. And it's also quite interesting to note that the split was really between Lord Burrows, whose background is that he's an academic, and the rest of the court, who it seems to me after reading the judgment was looking to try and establish some practical reality in that and some certainty as to how the parties to discussions regarding contracts could act in the future. So the majority held that bad faith was not an element of the analysis of this concept of law, but Lord Burrows delivered a dissenting judgment. The majority comprised of Lord Hodge, who gave the main judgment, with whom Lords Reed, Lloyd-Jones and Kitchen agreed. Now the parts that they agreed about, i.e. the court was unanimous, is as follows. Firstly, lawful act duress, including lawful act economic duress, does exist as a concept in English law. Secondly, there are three elements that need to be established for lawful act economic duress. Firstly, there has to be an illegitimate threat. There has to be sufficient causation, in other words, that the illegitimate threat caused the threatened party to enter into the contract. And thirdly, that the threatened party had no reasonable alternative to giving in to that threat. Now, when Lord Hodge was considering the first part, which is lawful act duress, including lawful act economic duress, as a concept, he referred to an article by Peter Burks, which is an introduction to the law of restitution, which is a 1989 article, which read as follows: can lawful pressures also count? What Peter Burks said in that article was, this is a difficult question because if the answer is that they can, the only viable basis for discriminating between acceptable and unacceptable pressure is not positive law, but social morality. In other words, the judges must say what pressures are improper as contrary to prevailing standards. That makes the judges not the law or the legislature, but the arbiters of social evaluation. Now, I think that is quite important because it seemed to play a large part in the reasoning behind Lord Hodge's judgment. Now, the third element is, as the threat is lawful, the illegitimacy of the threat is determined by focusing on the justification of the demand. And what Lord Burrows did is drew an analogy with the law of blackmail. And he referred to the case of Thorne and Motor Trade Association, which is a 1937 authority, where he quoted, it said, "The ordinary blackmailer normally threatens to do what he has a perfect right to do, namely communicate some compromising conduct to a person whose knowledge is likely to affect the person threatened. Often indeed, he has not only the right but also the duty to make the disclosure, as of a felony to the competent authorities. What he has to justify is not the threat but the demand of money." Fourthly, a demand motivated by commercial self-interest is in general justified. Lawful economic duress is essentially concerned with identifying rare exceptional cases where a demand motivated by commercial self-interest is nevertheless unjustified. Now, the class of activity that can fit into that definition, I would suggest, is quite small. As for the disagreement between their lordships, it's the issue of bad faith. In Lord Burrows' opinion was that it would be possible to make out a claim for lawful act economic duress if the claimant could establish that the threatening party was in bad faith when it made its demand of the threatened party. Thus, in the case of a demand for payment of money, the threatening party would be in bad faith if it knew it had no legitimate entitlement to the money. And therefore, in the case of the PIAC and TT, had the airline known that it had no defence of the claims for past commission when it demanded the waiver in the new contract under the threat of termination of the existing contract, then the airline would have been in bad faith and lawful act economic duress would have been made out. Lord Hodge disagreed. He said, firstly, there is no doctrine of inequality of bargaining power. He said as follows: in commercial life, many acts are done under pressure and sometimes overwhelming pressure.
In negotiating a commercial contract, each party to the negotiation seeks to obtain contractual entitlements which he or she does not possess, unless and until the parties agree the terms of the contract. Inequality of bargaining power means that one party in the negotiation of a commercial contract may be able to impose terms on a weaker party, which a party of equal bargaining power would refuse to countenance. Equally, where a party in a strong bargaining position, such as a monopoly supplier, may refuse outright to enter into a contract which the weaker party desires or may impose terms which the weaker party considers to be harsh. The courts have taken the position that it is for the Parliament and not the judiciary to regulate inequality of bargaining power, where a person is trading in a manner which is not otherwise contrary to law. Secondly, Lord Hodge says that there is no general principle of good faith in contractual dealings. He said the English law of contracts seeks to protect the reasonable expectations of honest people when they enter into contracts. It is an important principle which is applied to the interpretation of contracts. But in contrast to many civil law jurisdictions and some common law jurisdictions, English law has never recognized a general principle of good faith in contracting. Instead, English law has relied on piecemeal solutions in response to demonstrated problems of unfairness. He then refers to, in his judgment, which I think is again quite important, an extract from Professor Beatson's book called The Use and Abuse of Unjust Enrichment. And this is a passage that he quotes: "All that is not prohibited is permitted, and there is no general doctrine of abuse of rights. If therefore a person is permitted to do something, he will generally be allowed to do it for any reason or for none. In the context of contractual negotiations, this position enables people to know where they stand and provides certainty as to what is acceptable conduct in the bargaining process, but it does leave many forms of socially objectionable conduct unchecked." Again, this is soundly based for judges. Soundly based as judges should not, as a general rule, be the arbiters of what is socially unacceptable and attach legal consequences to such conduct. So accordingly, according to Lord Hodge, the scope for lawful economic duress is extremely limited. Now, so he disagreed entirely that we need to bring in an element of bad faith. It doesn't matter in his view that somebody acts in bad faith as long as he was legally entitled to do what he did. Now, so looking at the time, I'm coming up to the my half an hour. So in conclusion, where does that leave the law at present? Now, I think, or it's my view, that it's clarity is what was required, and clarity is what has been given with this judgment. In Morley and RBS, the party with the stronger bargaining power was the RBS, even though morally one might consider that the actions of the Royal Bank of Scotland were not warranted. They were perfectly entitled to do what they did, whether they were acting in good faith or not. Now, had bad faith been established as an indicator of illegitimacy in respect of lawful economic duress, the Supreme Court would have had, in its essence, been establishing the courts as arbitrators in a fact-finding analysis as to what was in the mind of the threatening party at the relevant time to establish whether it was in bad faith. It would have imposed an objective analysis in respect of what was a subjective decision-making process or negotiating tactic, and would have left quite a lot of uncertainty as to how people would approach contractual relationships in the future. So the risk that the Supreme Court was avoiding was that the legitimate commercial rough and tumble in negotiations would cross the line into illegitimate actions, and that is an area in which they were not prepared to go. As the court took a very restrictive approach to this area of law now, it does appear that lawful economic duress, although existing as a principle in English law, will be very seldomly applied, and would be some severe circumstances or factual background in which it would be applied. Therefore, the Supreme Court, in my view, set a very high bar for establishing the law of economic duress. And as I've already said, it brings a large degree of certainty to the doctrine and significant comfort for contracting parties, particularly those holding the whip hand in negotiations. Thank you.
Thank you, Avatar. You won't see me for a moment just while this slides up, but I am Natalie Kearney. Some of you may know me. I'm one of the junior members of the Insolvency team here at St Philip's. I'm going to give us a bit of a whistle-stop tour through personal guarantees. And for those of you thinking, why is this relevant to insolvency? Although I'm sure you aren't. We're seeing a lot of cases at the minute, particularly in relation to bankruptcies, where you have companies that are struggling as a result, perhaps, of the current climate, that go under or into administration or being wound up. And directors inevitably quite often give a lot of personal guarantees. The link to economic duress is perhaps somewhat obvious. And a lot of these directors turn around and say, I had no idea what I was signing, or I had to sign this, or my business couldn't continue. And so what we'll be looking at is, first of all, an overview of what is a personal guarantee. As I said, that's very much a whistle stop. For anybody who was very keen during lockdown 1, there is a webinar on this from 2020 that was available on the St Philip's YouTube channel if you want to look at that in more detail. I will briefly go through the formalities that are required. I'll have a look at the common issues, and as part of that, we're going to look at a case from February of this year. It's only a High Court case, first instance decision. It's actually quite helpful in going through what's required and the issues that we quite often face when trying to enforce a personal guarantee. Now I appear. So in terms of what is a personal guarantee, I'm not going to try and teach you to suck eggs. All of you, I'm sure, are familiar with these, yes, quite often. It's in essence a secondary obligation rather than a primary obligation. Usually it's contingent upon a principal failing to perform some obligation. Typically that means they fail to pay an invoice, for example. An indemnity, I'm not going to go into any great detail on that, but sometimes they're within the same document alongside one another, but you do need to know which one you're relying upon, if it's one, the other, or both. An indemnity would be a primary obligation rather than a secondary obligation. The most frequent time we see these is credit account applications. In terms of formalities, what you need to be looking for, are there sufficiently certain terms in your guarantee? And is it a continuing guarantee, by which I mean, is it an all monies guarantee? Is it on a credit account guaranteeing that if the company doesn't pay the ongoing level of credit, then the guarantor is responsible for that ongoing credit? And that may include, for example, the initial credit account was limited to £50,000 and that's subsequently been increased over time to £250,000. Is that all within that guarantee, or is there some specific limit in the wording of the guarantee that means that not all of it is in fact guaranteed? You may find that you're dealing with an on-demand guarantee. That's quite common and actually can be quite advantageous if you're the creditor from a limitation point of view. So where we have an on-demand, you will need to check what the requirements are for that demand. Where does it have to be made? When does it have to be made? Is it restricted to certain addresses, for example? And in terms of limitation, as you're aware, underhand 6 years, deed 12 years. But if it's an on-demand guarantee, typically that will mean that limitation won't start to run on the guarantee point until the demand is in fact sent. It may be beneficial in that respect. In terms of formalities again, the statute of fraud 1677 is where we start, a nice ancient piece of statute. In short, is your guarantee in writing and has it been signed? There are 2 cases I set out there, Pereira and Meta, 2006. That's the case regarding whether a document is in fact in writing. In short, if you have emails that can satisfy the requirement that an agreement is in writing, it used to be that obviously had to be a signed document prepared by the parties, but an exchange of email correspondence, a chain of email, can be sufficient to satisfy the statute of fraud section 4. And then in terms of signatures, it can be sufficient, and here I'm talking about the case, second case there, Golden Ocean and Salvacar Mining 2011 in the High Court. It can be sufficient that you've typed in your name at the bottom of an email. That may be sufficient. That, in that case, was an interim application, so it wasn't a finding based on all the facts of the case, but is helpful guidance in that respect. And it appears from the case law that in essence, the court simply has to be satisfied that something has been entered into that document, into that chain of emails, that was intended to act as a signature. It could be a pseudonym, it could be initials, it could be a string of numbers, for example, as long as it's clearly intended to be a signature on behalf of that organisation or that individual to act as a guarantee. And if you have it in writing and you have it signed, it's most likely satisfying section 4 of the statute of frauds and you have the formalities met. Which brings us then on to, what are you likely to face when you're trying to enforce a personal guarantee? The common issues are listed there. So you have consideration, by which I mean, if the guarantee is signed underhand, as you'll all be familiar, there has to be consideration given. The usual contractual principles apply. It's not quite so straightforward, and you don't have to look at the adequacy of any consideration that's been given. You simply have to show there has been some consideration given. A common example of this is where a director signed a personal guarantee underhand, and they say, well, it was credit given to my company, not to me, and that's not adequate consideration for a guarantee to be enforceable. Typically, the courts aren't with them on that. They are the director of the company, they are running that company, they are indirectly getting a benefit, their company is benefiting from them signing that guarantee document. And so normally you'll find that as adequate consideration. On the other hand, if you've got Joe Bloggs, who is a more junior employee signing a personal guarantee, you might find it more difficult to satisfy the consideration point in that respect, because they aren't necessarily getting the same benefits when they're just an employee rather than a director. The second issue you might come across is limitation clauses. And is there a cap on the guarantor's liability? And it's often overlooked. I have seen cases where there have been, for example, there's a guarantee of a loan. That loan in a separate document is written off after a set period of time. In short, if your liability is capped at the level of the loan and the loan is then written off, your liability under the guarantee will be zero, won't it, typically, depending on the fact of the case. So do check out for limitation clauses in related documents that may apply, that might catch your client out. In terms of being on demand, I covered this briefly already. Check what the requirements are, the addresses that you're required to serve. Check the wording. You don't want to find that you've brought a proceedings to enforce a personal guarantee and you're struck out on the basis that you haven't served a valid demand in the first place. And I've already covered the question of limitation. There's then the question of undue influence. I don't intend to spend a great amount of time on the undue influence point. There is, of course, a presumed undue influence in relation to spouses, doctors and patients, for example. I'm not going to cover it in any great detail for our purposes today. Essentially, if a spouse has guaranteed their partner's business, it's going to be presumed, in most cases, they've signed under undue influence, subject, of course, to them being involved in that business as a co-director, which brings into different considerations. Another example is our Joe Bloggs example a moment ago, where directors told Joe Bloggs if he doesn't sign this, he's going to lose his job. And so there you might look at undue influence. In terms then of guarantors' rights, typically speaking, if the principal that you're guaranteeing has some form of defence to this, a counterclaim, a cross-claim, a set-off, then typically the guarantor is entitled to raise that as a defence to the claim on the demand, under the guarantee, forgive me. The next point is economic duress. Avatar's given us a nice breakdown of that and the requirements for that. And we'll look at that in some more detail when we look at the case that I'm going to go on to in a few moments. And the final point there is the question of the underlying transaction. Has that been varied? If there's been a material variation of the underlying contracts, then that can prejudice the guarantor and may in fact have them discharged from the guarantee. As you can imagine, this is very fact dependent. It doesn't typically apply to an all monies guarantee. There's a case called Bellamy from 2013 in which that principle can be found. In some circumstances, if you've got co-guarantors and the creditors released the co-guarantor from their obligations, then that may also discharge the second guarantor unless they've consented to the release. But again, this is very fact dependent. So if one of these situations arises, it's always worth taking advice at that point in time on your specific facts and your specific wording. Now that brings me on to a practical example of somebody who tried to apply perhaps most of these in resisting a personal guarantee. Now, the case of Insta Group Limited and Carroll and another, it's a High Court case, as I say, judgment was February of this year, so very recent. It is only first instance, but if anyone is facing a claim for a personal guarantee, this very helpfully goes through the law that applies in relation to each of these respective issues that were raised. Mr. Carroll was one of two defendants originally. The second defendant, in fact, settled shortly before the trial. So Mr. Carroll proceeded on his own. He was, at the time of trial, acting in person as well, but his defence had been prepared by counsel, and he had had solicitors instructed at an earlier stage. So his pleadings, in fact, were based on professional submissions, and he simply took it to trial on his own. And we'll see how he got on as we carry on. In short, Instagroup was a manufacturer and supplier of insulation materials. It subcontracted the insulation materials to some third parties, and that included a company called Warm Space. Warm Space went into administration in around 2017, and it was quite common ground. There was really no distribution to any of its unsecured creditors. Warm Space was subject of management buyout in 2015 by Mr. Carroll and his co-defendant. As part of that restructure, the buyout in 2015, there was an attempt to reschedule some payments. So some money was owing from the company Warm Space to Instagroup Limited. As part of that buyout, they wanted to reschedule the payments that were being made to Instagroup. As part of those negotiations, Instagroup required Mr. Carroll and Mr. Barclay to enter into personal guarantees. There was about, at that time, around £500,000 worth of outstanding debt. By the time we get to trial, we're talking about sums of 1.5 million. Not only in relation to unpaid invoices, but also some overpaid measures, because it's all related to insulation schemes that subsequently were found not to meet certain government requirements for grants and the like. But we don't need to be too concerned with that at this point in time. Then looking in particular at Mr. Carroll, at trial he was running 4 main arguments. The first was economic duress. He said that he signed that personal guarantee in circumstances that were unconscionable, and he should therefore not be bound by the guarantee. We'll look again at what the particular circumstances were in a moment. His second was that there was no valid consideration given, and the credit application form was not a deed, so therefore there is a requirement for consideration. Thirdly, that he was induced to enter into this agreement as a result of fraudulent or negligent misrepresentations by 2 representatives of Insta Group. The fourth was that the claimant should be stopped from enforcing the guarantee because of certain representations that were given. Now, a lot of the facts of this focused on what was said and what wasn't said in a meeting in May 2015 before the personal guarantees were signed. And so it was very fact-dependent and witness-heavy case. If we look firstly at the question of economic duress, it was suggested that the claimant's representatives told the defendants that unless they signed the credit agreement account application forms incorporating that personal guarantee, the claimant would stop supplying materials to Warm Space, and Warm Space couldn't trade without those materials. The defendant said that would also stop them from operating a buyout. Now, going back slightly, at the original date in May 2015, Mr. and Mrs. Hennessy were the owners and directors of Warm Space. It was Mr. Carroll and Mr. Barclay that were seeking to buy out Warm Space at this point in time. That's why they were being asked to give these personal guarantees. He was saying that this action, the ceasing of supply by Insta Group to Warm Space, would mean that the buyout couldn't proceed either. It constituted illegitimate pressure. As Avtar's covered in great detail, so I'll cover them briefly, there are 3 elements for economic duress: an illegitimate, albeit lawful threat, threat that caused them to enter into the contract, and that there was no reasonable alternative to be taken. In this case, it was said the claimant's threat to stop supplying Warm Space was critical to the survival of Warm Space, and that was the threat. That was an illegitimate, albeit lawful threat. Now, on the facts, the judge in fact found that no threat was ever made at that meeting in May. But in any event, it said that demands wouldn't have been reprehensible or unconscionable. And at paragraph 82 of the judgment, the request for personal guarantees was one which would be justified by the commercial self-interest of Insta Group. Now, that seems to me it would apply to most cases where you seek a personal guarantee for a debt. If you are a creditor, you are seeking to secure the debt by way of personal guarantee, that's going to have a legitimate commercial interest behind it in most cases. Again, in this case, there were actually alternative suppliers available to Warm Space as well. So it wasn't the case that this was the only supplier, wasn't the only airline providing flights to Pakistan, for example. There were other suppliers available. And interestingly, at the bottom point there, in this case, Mr. Carroll's evidence was that he signed on legal advice from solicitors. The guarantee was unenforceable. So he told the court he'd been to a solicitor's firm, he'd taken a personal guarantee document to the firm and said to the solicitor, this is what they've asked me to sign. And his evidence was, and we may never know what was in fact said, well, the solicitor told me it wasn't worth the paper it was written on, it was really poorly worded and they wouldn't be able to enforce it anyway, so I signed it. I can feel you cringing at home as I cringe here. terrible, terrible thing to do, as you would imagine. But that also meant the judge found that even if there had been some unconscionable threats, it wasn't causative, because the reason he signed the personal guarantee was arguably, in fact, because his solicitor told him it wasn't enforceable, not because there was some threat made to stop supplying warm space. And so if you find yourself facing an economic duress argument, Avatar's already pointed out it's a very high hurdle. And in most cases, I can't see a situation where you would find any facts that would support duress, but of course, never say never. Turning then to the second point that he raised, the failure of consideration. As I said, unless you've got a deed, we're going to have to look at the question of consideration. It isn't a case whereby the consideration has to move from the promisor to the promisor, forgive me. It's satisfied simply when the benefit is conferred on a third party. So in our credit account example, there is an offer to extend credit. The company's obtained a benefit, and that will be sufficient in most cases for consideration. In this case, the defendant said the credit account application form contained a unilateral promise, and the court said, well, consideration was the claimant agreeing to supply goods on credit, which was, the defendant said that wasn't adequate consideration. But the court said at paragraph 89, the promise by the claimant in dispute to supply goods on credit is in principle good consideration for the personal guarantee. The claimant is promising they will continue to supply goods to the company of which the guarantor is a director, in return for the promise by the guarantor that they will stand as surety for the company's debts. And then at paragraph 90, it went on to say that it was also part of a larger transaction. As I said, part of this arose because Mr. Carroll was trying to buy out warm space from Mr. and Mrs. Hennessy. As part of that, they were trying to restructure the payments being made to improve on existing debts. So it was part of this broader agreement to reschedule payments as well that there was consideration given, not just in respect of the credit account. So Mr. Carroll's not doing very well on his first 2 points. He then comes on to the question of misrepresentation, and he's saying there is fraudulent or negligent misrepresentation. Now, quick whistle stop of the principles, as I'm sure you're all familiar. Contracts can be rescinded for both negligent and fraudulent misrepresentation. A person seeking to rescind must establish the 3 points set out in the slide there. A statement of fact was made which amounted to a representation. That statement was false, and the statement must be made by or known to the other contracting party. So I could tell Rob something and then contract with Avatar, but if Avatar isn't aware of what I've said to Rob, then it's not a relevant factor of entering into that contract. Now, for negligent misrepresentation, the representation must be one which the representor has no reasonable grounds to believe and which induced the entry into the contract. So, but for that representation, they wouldn't have entered into the contract at all. But for fraudulent misrepresentation, it's not quite as strict. It's sufficient that it's a factor in the decision to enter into the contract. It doesn't have to be the sole reason. But you must also establish it was made knowingly, without belief in its truth, or it was recklessly made. Now, what was Mr. Carroll saying in this case? Well, he was saying that there was a representation made at a meeting in May 2015. Various statements are pleaded, and I've set out 2 there in the slide. Don't worry, it's not our policy to use this as a way of holding you personally responsible for the debt. To be honest, as a guarantee, it's not worth the paper it's written on. And secondly, we would never come after your properties like that. I'm sure you all have your own views as to whether anything like that would ever be said by somebody trying to get somebody to enter into a personal guarantee. But on the facts of that case, we had 4 individuals that were said to be present at the meeting. There was Mr. Carroll and Mr. Barclay and 2 representatives from the claimant, none of whom had any clear recollection of what was said specifically at that meeting by the time they got to trial in February of this year, perhaps understandably with 7 years on. On balance, the court held that the representations hadn't been made. At paragraph 94, it's inherently unlikely a company would have standard form credit applications with a personal guarantee if they never enforce them. It might have been said by the claimant's representatives that they wouldn't enforce the personal guarantee except as a last resort. That's perhaps not an uncommon refrain. They aren't typically sought as the primary way of enforcing a debt. But even if that had been the case and that had been said at the meeting, it would have failed on causation, because the judge found that it was accepted on those terms to get a change to the payment schedule, and as we've covered, he'd taken legal advice anyway. And so on the facts of that case, there was no misrepresentation, negligent or fraudulent, such that the agreement could be rescinded. And then this 4th point, estoppel. That was based on very similar facts. Again, these representations said to have been made in May, and there was a subsequent phone call at the end of May, referred to Mr. Carroll as well. Again, iterations to the effect. They told me they would never enforce it. They said they never really do. It's just a policy to get it in writing. They promised me they wouldn't enforce it. They can't now enforce it. They should be stopped from enforcing. On the findings in that case, no representations were made to that effect, and so there was no estoppel that Mr. Carroll could rely upon. So if you do find yourself facing a case regarding enforcement of personal guarantees, that judgment is 22 pages long, I'm afraid, but does go through in greater detail the law that applies, the factors to consider, and what the court will be looking for. Mr. Carroll, unfortunately for him, was unsuccessful in its entirety and found himself liable for in excess of £1.5 million under the guarantee. So from a practical point of view, and what this perhaps helps you with, is what should you be checking when you're looking at a personal guarantee? So first of all, has the Statute of Fraud 1677 Section 4 been complied with? So is it in writing? Is it signed? Are your terms sufficiently clear? Are you looking at an on-demand guarantee? Is it an all-monies guarantee? Is it a deed, or are you going to have to look for some sort of consideration to apply? It's not particularly high hurdle, as we've said, if you've got a director for a credit account. But if it's a deed, it's perhaps easier. You haven't got to concern yourself with finding the consideration. Has independent legal advice been suggested? That's perhaps more relevant if you're looking at these undue influence cases where you've got spouses guaranteeing debts, for example. Then you want to look at the circumstances in which it was given. Is there any suggestion there could be any economic duress? Again, though, bearing in mind that's a very high hurdle for the guarantor to meet. If it's an on-demand guarantee, have you checked the requirements of demand? Have you met those requirements to giving demand notice? If not, then you're going to find yourself in difficulty further down the line. So it's best to get it right at the start. Check whether the underlying contract's been varied, and if there have been material changes, have they been consented to? Would the principal have a defence or a set-off or counterclaim? And then finally, is there a cap on liability that you need to be concerned with in that document or in related documents that may apply? That was a whistle-stop tour through personal guarantees, slightly under 30 minutes. That gives some time for any questions and answers, I think. Anyone wants to be brave and ask anything?
Well, I think the brave ones are those who are going to attempt to answer them. We've got, well, this is the risk, I suppose, Avatar, with choosing a very topical topic. You get a very topical question. So this is a question that's come in from somebody who's remaining anonymous, but they shouldn't, because it's a very interesting question. Could economic duress apply in employment settlement agreements, including gagging provisions? Take, for example, an employee has a civil claim. The employer offers to oversettle the claim for silence, including silence about acts contrary to the law, that's the carrot, or the stick, force the employee to go to the court or employment tribunal where they will face an army of lawyers deployed by the employer.
Yeah. The answer to that is yes, economic duress could apply in an employment settlement agreement. On the scenarios that you set out, I doubt that it will apply because, firstly, as I said earlier, was the threat illegitimate? Now, illegitimacy was defined by Lord Hodge as being something that where the defendant has behaved in a highly reprehensible way, which the courts have treated as amounting to illegitimate pressure. It's a wide definition, but I'll come back to that in a minute. The third criteria was that the threatened party had no reasonable alternative to giving in to the threat. Well, in this example, the employee does have an alternative. He could go to court. What has been said by the employer, such as they're going to have an army of lawyers, is their right to have an army of lawyers. There's nothing illegitimate about that. He or she may have accepted the increased payment for silence. That was a choice that they made also. It was open to them not to reject it. And I doubt very much whether, having accepted a settlement on that basis, that the employee is going to have much sympathy from the courts to go back and say, well, I was forced to do it, because it doesn't seem to me that they were forced to do it. It was a choice that they made.
Super. Wonderful. Well, thank you both very much for excellent talks. Thank you everyone for joining us. Tomorrow we have got an update on personal insolvency law, and then to finish us off, James Morgan QC talking about misfeasance. So I hope you can join us for that.